नहीं ये वो तो आप निकल ये तो ये कौन सा है नहीं वो तो
So, inshallah, starting the program. So, I would like to share the hadith of Rasulullah sallallahu alaihi wasallam, Bukhari hadith 2738. It is Rasulullah sallallahu alaihi wasallam said, it is not permissible for a Muslim if we have anything to write, make a will for that or make a testament for that, and he sleeps for 2 nights without taking care of that. So he should be prepared that. So again, it's important for everybody to take care of this part also. Can you guys hear me? Yeah. Well, most of you know me, but few of the ones that do not. My name is Umer Khan. I'm an attorney. I'm admitted to State Bar. I'm also admitted to Supreme Court. Also admitted to U.S. District, Central, Northern, and I'm also admitted to U.S. Federal Bankruptcy Court. So within this scope, if anyone has any question, they're most welcome to call me. So what we're going to talk about is trust. What is trust? What is will? Why would someone will choose trust over will? And then at the end, we'll talk about Sharia, how the Sharia is interconnected with the trust. So, and what happens if you don't have the trust and you don't have the will? So, first, the state that we live in is a probate state. It means that if you don't have the trust and you don't have will, you will go through probate. Many, many times, even if you have a will, the will still go through probate. What probate is? Probate is a legal process where the probate judge will decide who's going to be the executor of the will, and then will enforce the will, but is upon the discretion of the judge. Plus, the probate is a very, very expensive and a long process. I have seen probate litigation, I do probate litigation, is go over a year, and it's very expensive. So if you have, let's say, 100,000 in your assets, and you have no trust, you only have will, you're probably looking at anywhere from 10% up to no half is going to your legal cost and probate cost. So for someone who has assets, even the asset as small as 10,000, I think it's very, very unwise not to have a trust. And trust, what trust is basically a legal formation by a lawyer that follow your instructions that how you want your assets to be disposed and how you want your assets to be given to your family members and your friends and your family. Now, if you don't have a trust, then some people will have a will because they think they can take a cheaper route and get a will. The problem when you have a will is you still gotta go through probate. But beside the probate, there is so many ways you can attack a will or you can defeat a will. I see people raising claim against the authenticity of the will, that the will is not accurate, it's not executed by the right person, it's not witnessed by the right person, it does not have a language, they contest the will, and they contest the body of the will, and is a very, very common claim in the state. It doesn't have to be disputed by a family member. Anybody that you have come across in your lifetime, they can dispute the content of the will. And if they do, that opens up litigation. And then what happens is you have to incur all these costs to defeat the claim. It can drag on for 6 months to a year, and you have to come up with that money from your pocket. I mean, I had an experience with a client that retained me for a will contest that was contested by somebody that he has some affiliation with in the past. The will was only for $135,000. The legal cost to defend that will was close to $68,000. So it means half of the assets were depleted by the legal cost. And the person was disputing the will, they dragged this, be filing bogus motions, they dragged the process for almost a year and a half. The cost of formation of trust is so nominal that, in my opinion, for someone not forming a trust because they want to save a couple of thousand, I think it's very unwise. I think it's silly. Because there is no way you can shield your assets here in this state. Now, what the trust is, as I mentioned, is a legal document that a lawyer, an attorney will draft a legal paper, and which is consisted of few items, few segment of the will of the trust, and it has right language in compliance with the estate rules and the probate rules, is properly written, it has the list for all your assets. It allows you to have a right power to dispose your assets. It gives you a power in the compliance of the law to dispose and manage your assets. Okay? Now, a lot of time, the clients, they will go online on LegalZoom or different online software, and they will form the will. More than half of my litigation is trial that I'm dealing with, issue that I'm dealing with is people have gone either to Amazon or different bookstore or online and pay a few $100s and had the trust drafted. What trust is, as I mentioned, that's a legal document. So it means that it has to be customized based on everyone's needs, what your needs are. It's just like your personal taxes, your prescriptions are customized, what your needs are. So the trust has to be customized. And what happens is when you get those online do-it-yourself trusts, what is that? These are the broad language. It's just a broad language that tells you how the properties are disposed, what your power is. But every single time I have seen it missing the right legal language. And the law is so specific that even if you're missing one content of a law within your trust, that will open up doors for litigation. It is very easy to litigate the trust. Now, if you're missing a legal language, what will happen, you will not face substantial issues while you're alive, but God forbid, after your death, the family is going to have to absorb the cost, because by not having the proper language, it can invalidate the trust. And it happens every day, it invalidates the trust. So, my opinion as a lawyer, try not to go online places and try to draft the will. The primary reason is that these are your assets. You have worked hard your life. Either it could be 5,000, 10,000, your home, your vehicle, you have worked hard for it. This is something belongs to you. After you, it belongs to your family, your children, your spouses, your family members. And just for the sake of saving few $100, it's not wise to avoid the cost of the trust. If trust is costing thousands of dollars, I can see that, but honestly, it really doesn't cost a lot of money to form a trust, but in the long run, you will have much better peace of mind. I'll give you an example. You are disposing, you own a house, you have an account, you want your spouse to have access to that account upon your death. You want your spouse to have a power upon your death to dispose your assets. If the right language is not drafted, is not part of the trust, that assign different obligations to the trustee, then it invalidates the trust. And people will raise claims on it. So, by saving money, it's not wise to cut corners against the law, because things have to be compliant. It's very black and white. There is no broader picture on it. Now, why trust in our state? As I mentioned earlier, the trust, one of the major reasons the trust should be drafted in our state, because our state is a probate state. We have one of the most strict probate laws. And since we don't have a lot of probate judges, the probate dispute litigation trial takes time and it's very, very expensive. Plus, if you don't have the trust, the biggest risk that you take, as you know that in here, it's very easy for people to file a claim against you. People, a lot of my brothers have come to me, they have judgment against them. So it's a much easier process to file a claim, file a collection against someone. If you don't have the trust, it is much easier for your creditors or anybody that's seeking a claim against you to place a judgment against your property. It's very simple to place a judgment or some form of lien against your property. And what it does, it clouds your property. It will cloud your accounts, it will cloud your tangible assets, it will cloud your personal assets. It's so easy to do it. Other thing is, with that trust, everything is so private. When it comes to will, you are exposed to the public. What the trust has is a legal document. It lists all your assets. It specifies your instructions that how you want your assets to be divided among your family members. So it's a private matter among you, your family, and your lawyer. The outside public doesn't need to know the content of the trust. Trust is a safe document which, once you get drafted, you'll be in a safe place. Your beneficiary will have the trust. Your lawyer will have the copy of the trust, and the outside public has no clue that the ownership of your assets. If we take a will, you are exposing yourself to the public. Why? Because the will spells out what your assets are, because the will has to get probated. So if I give a will, if my father gives me a will and say upon his death, the house will belong to Umer Khan, well, the will doesn't allow me to take the ownership. It has to go to the probate court, and the judge has to go through the whole process, and then at the end will either grant me the house or it would open up litigation. Every single will has to be probated. So if we think that by having a will, we're able to achieve our goal as far as disposition of our assets, no, we can't. We will not. So what happens? The will is a public document. It means any assets you have, the money you have, properties you have, it just gets disclosed. The public knows about it because it's in a public docket. Anybody can look at the litigation of the will and they will know what someone has. When you have a trust, it's a shielded, safe document because the public doesn't need to know. Okay? Because it does not go to the probate. It does not go to the court process where the trial will open up and where the litigation will open up. Okay? So that's the biggest benefit that you get by having a trust over compared to a will. Plus, what it does, what the trust does, is allows you to control your assets. Assets in the form of cash, assets in the form of jewelry, assets in the form of share, in the form of your 401k. It allows you to control and manage your assets. Where the will not allow that, because what happens, will goes in effect upon your death. I want you to listen very carefully. The will goes in effect upon your death. So if somebody is severe ill, they are not able to mentally make decision about their financial disbursement. They are not in a physical condition to finalize or instruct someone that how their assets will be disposed. They are locked in because the will only goes in effect upon the death. Before the death, the will is not in effect. Where the trust is that you provide instructions to your lawyer how you want your assets to be distributed. So the trust will allow you to follow the instruction as you will. And it will walk through the whole process with every step that how the properties, assets, and your money will be distributed at the end. Okay. Now, other thing as I mentioned that what happens if you don't have a trust? Well, you can manage your assets. You can decide how you want your assets shall be divided. Who's deciding for you? It's the judge. Judge is deciding. The attorneys, the probate attorneys are deciding. So it means that your family has no control over it. That's something that you have worked hard your whole life. You were able to buy the house, you were able to save up money, you were able to buy 401k and your stocks, but you have no control upon that. Okay. Your family is advancing the legal costs, advancing the court costs, but they have no control over it. Who has control is the judge, is the court, and as well the attorneys have control of it. So at the end, who will decide? Who will be decided by the court. Where you have a trust, then the decision is made by you how you want your assets to be disposed at the end. Okay. And I also mentioned that you have control over your trust during your life of the trust, and you can change, you can modify any way you want. How do you set up a trust? Okay. Well, what trust is, as I mentioned, is a legal document which specifies what your financial goals are. So the first thing when an attorney or a lawyer form a trust is what is the goal of the trust? What is the purpose of the trust? Because the purpose of the trust has to be in compliance with the state rules. Is it for the benefit of the family? Is it the benefit of the charity? Or has any special purpose that you want your trust to achieve? But the trust can only have a purpose for the welfare of the family and the welfare of the society. You cannot have an unlawful purpose of the trust. That's the first reason to have a trust. The second reason is you want to protect your beneficiaries. You want to protect your families. That's the second reason to have a trust. The third, you want to have a control on your money. You want to have a control on your assets. You want you to decide upon your debt how your assets will be divided at the end. One thing that the trust has, the will not have, is the trustee. Now what the trustee is someone who manages the trust, has obligations to follow the rules of the trust. It has obligations to follow the terms of the trust and have fiduciary duties to the trust, have obligations to the trust. It's like a manager of the trust. Okay? Where on the will you don't have that, is you will assign someone to execute your will, but it's upon the discretion of the person to decide. Okay? But here, you have that discretion, you have the power. Now, as a manager of the trust, if you are the owner of the trust, you are the creator of the trust. So let's say if I have a trust, Umer Khan Family Trust, well, I could be the trustee of the trust. I could be the manager of my own trust. And I can define in the trust how I want my properties, my home, my rental properties, my car, my bank account, my 401k, my assets will be distributed. So who's deciding? I'm deciding. So I could be the trustee of my own trust. In a plain language, I could be the manager of my own trust. Plus, I can assign somebody else also as a trustee of the trust. You can have more than one trustee. If Umer Khan is the trustee of his own trust, well, he can assign Shahab as the co-trustee of the trust. Okay. I can assign any other person for the trustee of the trust. So if, God forbid, if something happens to me upon my death, and I'm the trustee, then the second trustee comes in, and the second trustee will manage the trust. Then if, God forbid, something happens to the second trustee, the third trustee will come. After the formation of the trust, you can change who you want to be the trustee. Let's say I have myself as a trustee. I want to replace Shahab, somebody else. I can also do that. Within my lifetime, I can change the name of the trustee, and I can assign somebody else. On some of the trusts that I form and I draft, beside the trustor, the person who is the owner of the trust, they assign lawyer. And the trust, since the lawyers are very familiar with the rules and regulation, and is a very slight chance that the lawyer will commit any type of fraud. Okay. Now, so you name the trust, you assign yourself trustee of the trust, then what you do, then you bring beneficiaries of the trust. Beneficiaries mean your family members who are going to get the part of your assets and who will be entitled to get your assets upon your death. So once you identify your beneficiaries, then the last thing, you fund the trust. So we got 4 components. We have the formation of the trust, then we name the trust. That's Umer Khan Family Trust. You can name anything you want. Then you assign the trustee of the trust, who will be the manager of the trust. You could be yourself. Then you assign beneficiaries who will get your assets. And the last one, what assets? So that's basically putting the funding, the trust, which is what is consisted of the trust. If you have properties, that will become part of the trust. If you have your retirement, 401k, that will become part of the trust. If you have your jewelry, your cash, that will become part of the trust. Now, how would they transfer to the trust? So, let's say you have properties. I have a house. I want my house to be a part of the trust. It means there will be a legal document form, and then through the legal document, it will get a notarized, and then you will transfer the deed of the trust to the trust. Okay, the deed of the property to the trust. So if the property is under my name, Umer Khan, then the property will get transferred to Umer Khan Family Trust. Same thing if you have your 401k, you have your retirement account. You can assign your trust as a beneficiary of those accounts, and the way you do it is wherever you have your retirement, your 401k, and your share account, you send them a certification of the trust, which is drafted by your attorney and signed by you. You send them a copy, and what they will do within your retirement 401k stock account, they will add your trust as a beneficiary. So if God forbid, if something happens to me, my accounts will get transferred to my trust. It means the trustee will distribute my accounts. Same thing you do with your saving account. You assign beneficiaries, your trust as a beneficiary to your saving account. So if God forbid something happens to you, it doesn't get probated, everything gets transferred to your trust, and your trust does the disposition of the assets. Okay. A lot of time people get married, have more children, or they decide, they go through divorce. So at any of those occasions, you have the power as a trustee to modify your trust. Trust can be modified anytime. You can remove property, you can remove assets, you can add assets, you can remove beneficiaries, you can add beneficiaries. So you can do anything that you want to do as a trustee. If it's been drafted by a lawyer, you just have a lawyer to amend the trust. Okay. So the trust gets amended every few months, every few years. And I see clients, I have drafted their trust a number of years back, and their trust has been modified, every few years. Whenever you buy the property, what happens that before you take the title, lawyer will draft an amendment to the trust that this property XYZ on this street is becoming a part of the trust. The attorney will draft a grant deed, the grant deed gets recorded, and the property comes in the trust. The biggest benefit you're going to have that if anybody has a claim against you, they're going to have a really tough time because the trust is very difficult to go after the trust, and especially to seek a claim against the trust. So there's two types of trust. There's many kinds, but generally it's about two types of trust that people form. One is a revocable trust, and the other one is a irrevocable trust. Now, what is the primary difference? Revocable trust means you can revoke the trust anytime. And how do you revoke the trust? Whatever assets you have in the trust, you just give those assets to your family members and you love them, and you revoke the trust. Or you decide that you don't want to have a trust. So, in the revocable trust, trustee, which if you are the trustee of the trust, you have all the power of the trust. Okay, so as a trustee, as a settlor, as the owner of the trust, under the revocable trust, you will have power of the trust to modify, to change, to alter, to dispose assets, to bring assets, anything you want to do with the trust, to change beneficiaries, to change, giving somebody instead of 20%, giving somebody 50%, you can change all that in a revocable trust. You do not need approval and consent of anybody because you are the owner of the trust. And that's very crucial for all of us to know that do we want to do a revocable trust or do we want to do an irrevocable trust? Now what is an irrevocable trust means? It means you can revoke the trust. You are the beneficiaries of the trust. Which means beneficiaries will decide if they want to revoke the trust. Which means that in order to revoke the trust or make any changes, make any modification, and alter the trust, it has to get approved by the beneficiaries. Now, how you decide that do I need to get a revocable trust, a revocable trust? Based on each cases, based on each needs, the Lord decide that should you get a revocable trust, irrevocable trust. In some cases, you want to have a irrevocable trust. On some cases, you want to have a revocable trust. I have clients that has wrongfully formed irrevocable trust. There was no need for it. Some clients have formed a revocable trust, but they need the irrevocable trust. So the Lord will decide based on your needs that what type of trust you're gonna need to have. So the bottom line is as I mentioned, that if you do not have a trust, you are just exposing yourself to a lot of risk and a lot of exposure. Plus, you will not have any control on your assets. Somebody else will have a control on your assets. Plus, you are not the one is going to decide how your assets would get distributed. It will be decided by the judge or decided by the court. But if you have a trust that allows you to have all this power, means the first power, you're the owner of the trust. You're going to decide how the properties will get dispersed, how much percent of your properties somebody will get, and how you want your properties to be managed, how much cash somebody should get, how the bank accounts will be divided, how your 401k and your retirement account will be divided. All those instructions will be the part of the trust. When I draft trust, and when I have seen trust, the trust will categorize everything. How property A should be dispersed, how the property B should be dispersed, how your saving account, your checking account should be dispersed, how your retirement account, your share account, your 401k account should be dispersed. Every single asset that you want under the trust, it will specify every single asset. I have in some instances, I have clients also want me to categorize their cars, their jewelries, that how they want their jewelries and their stocks to be distributed, and that's all can become part of the trust. You can put anything that you like, any asset, tangible assets, cash assets, property assets to be a part of the trust. So that's a broad picture of the trust. Now, some of us prefer to have a Sharia trust. Now, what is Sharia trust? The primary difference that I have seen on a Sharia trust, that Sharia trust is based on religious rules, where the common law, the trust that we've been talking about is a common law trust. The common law trust is based on the laws. It's based on the state laws and in some cases based on the federal laws. With Sharia law, Sharia trust or Sharia laws is strictly based on a religious practice. It means there are some restrictions how your investment should be invested. How do you want your properties to be invested? And I'll give you an example. If you have a 401k and you have a retirement account, well, whoever is maintaining your 401k or retirement account, they invest that money. Sometimes they invest that money in mortgage bonds. Sometimes they invest that money on loan bonds. So what happens? They earn interest, and then the interest is your income. It goes to your 401k retirement, and your balances goes up because you earn money on it. Sometimes they will invest money on different level of investments, and that investment will produce income for you, will produce profit for you, and they will become part of your 401k retirement account. But some of those investments are not allowed by Sharia. I have a client that has a substantial amount in his 401k, and it was invested by a 401k holder. And when I checked it, where the source of investments are, well, they were investing, buying shares in stock of a company that manufactured beer and alcohol. My client wasn't aware of it, but the money was invested, the bonds were invested to invest money. Now, Sharia doesn't allow those type of investment. A common law, those investments are allowed, but Sharia doesn't allow those type of investment. Plus, the distribution based on Sharia is very different what we have in common law. Such an example, in a common law, you can give more to your daughter and less to your son. Based on a Sharia law, your son gets twice share of your daughter. Under the Sharia law, your wife only get 1/8 of the assets. But if is a surviving spouse, his husband, they'll get 1/4 of the assets. Plus, the Sharia does not allow lifetime gift, where common law will allow lifetime gifts. So there are some rules which are not allowed under Sharia, but they are allowed under common law. We as a lawyer, what we do, we form a hybrid type of trust. Hybrid type of trust means that it has the basic principle of the common law, but it has all the restrictions that's not allowed by the Sharia law, or whatever the Sharia law demands, we somehow incorporates into a common law. Now, let's say the Sharia law does not allow, it allows twice of the share that you give it to daughter to your son. Well, under the hybrid formation, you can change that. If you want daughter or the son wants to have an equal share, you can modify that. You can change that. If you want your surviving spouse to have more share than was allowed in Sharia, you can modify that. You can change it. I have some clients that they strictly abide by the Sharia rules, which is fine because it's a distribution. I can draft a trust. You will strictly abide by the Sharia rules. On some cases, I have clients that they would like to see that that I do incorporate Sharia rules, but they like to give some more assets and more share to the family member, which strictly can be done. But what happens that when you have a trust which is incorporated with the Sharia rule, the benefits you have while you are living, you can decide within the context of Islam that how you want your assets to be divided and distributed among your family. The judge could not decide it, the court won't decide it, lawyers don't decide it, I don't decide it, it's all decided by you. that how you want your assets to be divided and to be given upon your death. What it does, it protects you from any type of probate litigation, okay, and allow you to have a peace of mind. Plus, it allows you, if we have a hybrid trust, which is a combination of a Sharia law and a common law, it allows you to decide your inheritance right while you're living. It does not allow a court or a judge to change any type of distribution that you have in a trust. Okay. Plus, if lawyer is drafting the trust and the lawyer is managing the trust, then it also allows the lawyer and instructs the lawyer to have the distribution done based on your religious practices. So I have a number of clients that they like to see a hybrid trust where we stick with the basic principle of Sharia, but we also have a common law principles. Because of course we live in a country where we have to abide by the local rules, by the state and federal rules. So we cannot ignore the local rules, ignore the state rules and the federal rules, and just strictly have something drafted, which is basically on our Sharia rules. It needs to have a local rule, so your trust is enforceable, your trust is effective, and it basically avoids any type of issues and litigation. To have a hybrid trust, it does not increase the cost of the trust. And as I mentioned earlier, that most of the brothers and sisters, they don't form the trust because they think it's going to cost a lot of money. Actually, it does not. It really doesn't. It costs a lot of money. And the trust formations run anywhere from, if it's a basic trust, not much work, it runs you anywhere from $1,700 to $2,500 or $3,000. It's not much. If the complex trust, it's a little bit more, but it's not. And I do provide substantial discount on my fee when I draft the trust for any brother and sister. But by not having a trust for the sake that somebody wants to save a few $100s, I think it's not a wise move. I deal with the issues every day. That's what I do for a living. And a person might be saving money now, but I can guarantee you that in the long run, it will cost 10 times, 15 times more to your family members to try to hold the properties and try to have the maximum share of the assets for your instructions. So I advise my clients that you'd rather have trust done properly, abided by the rules and laws, so it's enforceable. It does not raise any type of dispute and problems at the end upon your death. It's a peace of mind. It's really a peace of mind. I see horror as a lawyer. I see horror stories very often. That people don't have a trust. Now they're trying to form the trust right at the last stage of life, where they don't have a mental capacity to really understand the trust. So this is the broad picture of the trust. I don't want to go into legalities of the trust, because we as a lawyer decide the legalities of the trust. But that's all on the broad picture of the trust. If any of you have any question, feel free to ask me.
So we start with this. The probate form available from the county, would that be a substitute to the will?
Well, probate form, you need probate forms to do a probate. So probate form it's not substitute. The only thing is substitute your will is your trust. So you cannot use a probate form. So yeah, you can. What it does is it just makes your probate easier. and you're able to specify and mention, indicate your assets in it, but it will not avoid and somehow safeguard you from litigation. Anybody can dispute the will.
So general understanding is to actually guard your house or something.
Well, you know, that's a general thought, it guards you, but what it does not do, if a creditor wants to come after you, they can come after you, and they can, anything after your homeowner exemption, which is I think 250,000 or something, they can go after the equity of your house, they can come after it. After the homestead, I think
Is there a
exemption.
threshold?
Yeah. Homestead give you exemption that if you are a single person, they just changed it a couple of years ago, I believe it's 250,000. So they can come, creditors can come up to a homestead exemption for 250. I believe if you're married is 350, but there's a caveat. If you purchase a property, if you buy the property, let's say I have a client and I'm doing a trial now. He purchased the property in 2017. 2017, the homestead exemption was only 125,000. His house has an equity of 900,000, and there's a judgment against the house for 560,000. So it means there is enough equity. So he has an equity of 900,000. First 125,000 they can come after, but even after 125,000 homestead exemption, he's still left with over 700,000 equity. The judgment is 560,000, so they can still come after. But if he had the trust form, it will deter your creditors, because it will be very difficult for them.
Completely, they will safeguard the whole.
It will say yes.
And was it with inheritance tax or they got death tax?
I'm sorry?
Inheritance tax in case of trust or will, is there any difference for that?
There is, I think there's something CPA can help you, but the inheritance tax in California is very minimum, very, very nominal. That's why I heard. So, in your county has some taxes, you have some implication for the property taxes. But as far as the inheritance tax in our state is very nominal. It's not too high.
You can add anything from abroad the country also into the trust, or
Okay. So it depends. Some countries don't abide by the rule of common law, and some countries abide by the rule of common law. Whenever we form a trust, of course we have a will in the trust, we have a certification of the trust. So we do include outside properties. I have a client that has some property in Pakistan, and the judge did honor the distribution of the assets. On some cases they don't. It's really depends on the local rules, or the local rules are. Every country has some probate rules. So it depends on the probate court which country you're from. But a lot of cases, the judges they do honor.
but you haven't done anything in Pakistan.
No, I've done many trusts for many
Have you
clients.
added
They have
anything?
assets in Pakistan.
Have you added anything in those?
Yeah, and land is a very common sort of property that people own in Pakistan. So I have
Absolutely.
lands. Yeah. I have a client that owns 54 parcels of land in Pakistan. So yes, I did include in your will. And it was enforceable. He was able to enforce it. They did enforce it.
I have a question. In 401k, you have already assigned the beneficiaries and the percentage they will get it. Do you still need the trust?
Yeah,
Because most of the time that I read, that trust rules or whatever your instruction are will not supersede the instruction or percentage you have given or assigned in the 401k already.
No, if you want your if you want your trust to instruct your 401k holder how you want distributions to be done, you can change it, you can modify, you can alter. You can provide them a certification of the trust and say you are changing it. People change it all the time. You can definitely change it.
But that you can change already over there.
But he's saying, is it sufficient enough?
No, it's not, because what's gonna happen, that if anybody dispute anything, okay, then it will open up probate. Okay, I'll give you an example. I had a client that had a 401k that had a lot of money in a 401k. Upon his death, one of the family member disputed the distribution of the 401k, and somehow he and she mentioned that that person was promised 15% of the 401k proceeds, and the 401k proceeds that he had was in millions. We went on litigation because we had to defeat that claim, but it was dragged. But if this thing was indicated in identifying the trust, then it will defeat any type of claim. So it would be wise to have these type of distribution to the in trust to avoid it.
So regarding this, so in 401k, let's suppose when you start the trust, you have $500,000. By the time you're dead, it's like $2 million. So is the trust needs to know the amount, or it doesn't matter if you start with 10,000, but at the death it was $2 million?
Yeah, what you can do is the trust just needs to know the initial investment. And then, so let's say if you start your trust with you start with your 401k 10,000, you indicate in the trust that you have 10,000 in your 401k initial balance, and you want your 401k to be distributed among your wife and 3 children, and that's how much percent they'll get. So if the balance goes up, the balance can go up. And the balance is 10 million, that's fine, but you have specified in your trust how you want your distribution to be done.
And it applies to any asset, if it's not like we're talking about stocks or something,
Yeah.
the time has to prove or something, it will apply the formula.
That is correct. That's correct. Yes. But at any time you want to change that, you want to modify it, you can also modify it. I mean, people change. Sometimes later on in fewer they decide they want to give this child more share, or this child less share. They want their spouse to have more or less share. You can modify it. There's an amendment. It's good to have every few years, every 3-4 years. It's really doesn't cost much money, only a few $100, and you can have your trust be amended and modified as you buy more assets.
Related question is like, go ahead. Somebody
Go ahead.
raised their hand.
Yeah. If someone has trust and after his death, he has a medical bill, Medicare or something, they can come to the trust.
So that's a very good question. So what happens in the trust? What we do, we also form a healthcare directive in a trust, where we direct the trust, instruct the trust, that how somebody medical treatment will be addressed and will be treated. So you can have the trust assign that how the medical bills will be paid. Now what happens if the medical bills are not paid? So it's going to be dependent what kind of trust you have. There is many trusts that they cannot come after the trust. They won't be able to come after the trust. We just have to add legal language in the trust and form a particular kind of trust that will differentiate you against any type of this medical claim. That's what we can do.
But if there is a lawsuit, the person and he passed away, so the lawsuit can go to the trust?
No. If it's against a person and person has been mistakenly sued for it, no, they cannot.
So my question is, based on your explanation, any asset which is depreciating as an any, like, they mentioned cars, or now for the medical, put their reverse mortgage and all that stuff, how does that trust handle it?
Well, the only thing you do is you just grant the property to your trust, and you specify the trust. That's all it is. So every single the ownership of the property will be under your trust.
So my question is directed, do we opt to put everything in there or actually selectively put the because, like, if we mentioned assets will be depreciating values like cars, or like I give you an example of reverse mortgage or something. Would that be a decision you made, or it's like in that sense, I'm asking?
Yeah, so what happens that you will, Sajid, give me your water.
Sure.
What happens that when we are forming the trust, then you decide what items you want to be listed in the trust. It's up to you. If you want something to be excluded from the trust, yes, you can completely exclude it from the trust. You don't have to put it.
There is a guideline about it, or it's just whatever you want?
It's upon your discretion. As a trustee, it's upon your discretion. How long did it take to finish one trust? It depends how complex the trust is. I mean, it takes me about 2-3 weeks to finish the trust. Yeah, because you have to write a lot of simple language in it, and then you sit down with the client 3 times.
And can you include this your business your bank account? Say you have a corporation.
Yeah. So what happens that if you have LLC and a corporation, we designate those things in your trust. So if you have an XYZ LLC, the XYZ LLC would be designated in a trust as a trust property. And that's the beauty, because nobody's gonna know. So if you have an LLC that designated in a trust as the property of the trust, well, only you know it, your lawyer know it, your family know it. But it is a part of the trust.
Can you use your tax ID as in your trust or social security, one of it?
What was that one?
The tax ID or social?
No, so what happens in a trust, some clients, they want to have a separate tax ID. So you can have a separate tax ID. If you want to use your social security number, you can have your social security number. If you like to have a separate account for the trust, and you don't want to mingle trust income with your personal account, then you just get a tax ID and you open an account. A lot of people, they just have their separate tax account, and they don't like to mingle funds. It really doesn't cost money or anything. It doesn't raise your costs. It just gives you more layers of protection for your assets. You can definitely do it.
Standard. How much is
It is, as I mentioned, the trust it will run you anywhere from 1,500 to 2,500 people for a simple trust. If somebody has very, very complex trust, I have some clients who have very, very complex trust.
What do you
Because
mean?
complex trust means they have a lot of assets, and they don't want to disclose assets. So what we have is, we have LLC that layer up their assets, and so those are more implications, and those trusts are more complex. But I think most of brothers and sisters, I think our trusts are very simple. We have personal property, rental property, you have some money in a 401k, retirement, they're very basic trusts.
Did they have a special masjid discount for people?
Yeah, sure. You know, when people call me, you know, I discount my fee 30% at the top, definitely for the trust. And I don't charge anything for as far as drafting the grandees or amendments or anything.
What do you suggest for a lot of people have a bank account, they have nothing like a $20,000 in their bank, and if they die, how are they gonna protect that money?
Yeah, so that's gonna get probated, as I mentioned earlier, that if you don't have the trust, it will get probated.
Even for $20,000?
No, it's better for 5,000 get probated.
I heard that there is you go to bank and you tell them, put the beneficiary in the bank, and they can say that certificate, and the bank will give you the money.
Some banks do, some banks won't.
So it doesn't go to probate if you're like former trustee or beneficiary.
You already have the name of the person with you. The bank account, huh?
He's a banking expert.
That's a joke.
Something you learn in IIT.
So, quick question down here. So if somebody wants to schedule an appointment with you, how can we do that?
You can
Just call you?
just call me and then I'll set up the time.
And back to the question which Sam raised.
Yes, yes.
Deed of trust.
And like you said, most of us here are simple. Trust.
Yeah, simple trust.
Okay, house, 401k, what's the cost of that? Just basic.
I think for a simple trust, you probably be, I mean, I have to look at the assets and I see how the assets are done. I think the most simple trust will probably be about 1700, 1800. I mean, 1500 is just, you've got to have an additional cost. The additional cost is a recording fee. Because the county will want to. No, there's no, then you have a trust.
You already have.
What do you mean? You don't have a trust, how you record
You
it?
have a trust already. You want to modify that trust. So that property will be recorded, right? So what would you?
If you, it depends on your modification, how old your trust is, how old your trust is. Yeah, for 10 years old, you're probably going to need some modification. I mean, modification is anywhere from a few $100 to $1,000.
Is there some maintenance fee for the trust to update and keep it now?
If you're not disposing, if you're not buying property, not disposing it, you will keep the trust the way it is.
So nothing added, nothing removed?
Do
Okay,
you also make LLC?
Yes.
so wasn't here.
It's like LLC.
Partner signed कर दिया.
People from LLC can separate their personal liability from the
That's
liability. It's the same applicable on a trust. If you form a trust with some rental property, just then it's separate out the liability.
Yeah. So what happens that sometimes you can have a property under the trust name, and then or you can have a property under your LLC or entities, and then you can assign the entities to your trust. That's what happens. So you have a LLC, you have an XYZ property, you have the property under your ABC LLC, and the ABC LLC is a part of your trust. So you can double it. Yes.